One-on-one. Coaching agreement. This coaching agreement, the agreement, is entered into as of the effective date. Throughout this agreement, the coach and the client may each be referred to as a party or collectively as the parties. Whereas, the client desires to retain the coach to provide certain services and to compensate the coach for its performance of these services. In the event of a conflict in the provisions of any attachments hereto and the provisions set forth in this agreement, the provisions of such attachments shall govern. In consideration of the foregoing and of the mutual promises set forth herein, and intending to be legally bound, the parties hereto agree as follows. Recitals. The coach has expertise in the area of the client's business and is willing to provide coaching services to the client. B. The client is willing to engage coach as an independent contractor and not as an employee, on the terms and conditions set forth herein. C. The client has spent significant time, effort, and money to develop certain proprietary information, as defined below, which the client considers vital to its business and goodwill. D. The proprietary information will necessarily be communicated to or acquired by coach and its agents in the course of providing coaching services to the client, and the client desires to obtain the services of coach, only if, in doing so, it can protect its proprietary information and goodwill. Services to be provided. Coach agrees to perform for client the following services. Such services are hereinafter referred to as services. Client agrees that coach shall have ready access to client's staff and resources as necessary to perform the coach's services provided for by this contract. The parties agree to engage in a one-on-one coaching session one time for 60 minutes through in-person, internet, or telephone meetings to help the client improve their business practices in their industry. Coach will be available to client as needed to answer client questions and review progress by email or coaching session for an additional hourly fee on a first-come, first-served basis. Coaching period. Basic term. The client hereby retains the coach, and coach agrees to render to the client services described herein for a period of a one-time 1-hour call, the coaching period, commencing on the date of this agreement and ending upon the date the coaching period is terminated by this agreement. The client shall pay the coach the compensation to which it is entitled through the end of the coaching period, and thereafter, the client's obligations hereunder shall end. Compensation. Late payment fee. Benefits and expenses. Compensation. In consideration of the services to be rendered hereunder, coach shall be paid $95 USD per hour for the hours worked during the coaching period. Client shall pay the amounts agreed to herein upon receipt of invoices which shall be sent by coach, and client shall pay the amount of such invoices to coach. Such compensation shall become due and payable to the coach in the following time, place, and manner. $95 per hour paid via PayPal, Stripe, or other applicable payment method upon invoice for one-on-one coaching call for 1 hour at a mutually convenient time of parties. Payment is due on the specified date listed on the invoice. In the event coaching call exceeds the 1-hour allotted time, the client will be charged an additional equivalent charge based on the amount of time exceeding the original allotment, such as half-hourly rate for 30 minutes or additional hourly rate per full hour exceeding original session allotment, will be billed by invoice and due on the specified date listed on the invoice, within 5 days of coaching session. Such as, for example, an extended coaching session on 1st of October. Additional coaching time payment is due on or before 6th of October at 11:59 p.m. ET. Late payment fee. If client fails to tender full payment owed to the coach under this agreement within 5 days after the due date above, then a late payment penalty of $50 in addition to total amount, the late payment amount, shall immediately be charged to the client. Client shall pay the late payment amount to the coach immediately, along with the total amount due as described in the paragraph above. In the event that a PayPal or any other legal dispute is filed against the coach, or a payment is overdue, the coach reserves the right to revoke all client rights to the work performed by the coach under the terms of this agreement, and all such work shall remain coach's intellectual property until the dispute is resolved. Coach reserves the right to use any means of collection available under applicable law to collect any amount past due. Coach may refer collection of the unpaid amount to an attorney or collections agency. If coach's unpaid invoices are referred to an attorney or collections agency, then client shall pay all reasonable attorney's fees or collections agency fees. Benefits. Other than the compensation specified herein, Neither coach nor its agents shall be entitled to any direct or indirect compensation for services performed hereunder. Expenses. Coach is solely responsible for payment of expenses incurred under this agreement unless such expenses are pre-approved by the client in writing. The client will only reimburse the coach for expenses that were submitted and pre-approved by the client in writing. Cancellation and no refund policy. Client agrees that once the coaching services are rendered to the client, there will be no refund issued by the coach. Client agrees that it is the client's responsibility to reschedule or cancel coaching sessions in advance of the scheduled calls and meetings. Coach reserves the right to bill client for a missed meeting or coaching session, unless 48-hour cancellation notice is provided by the client to the coach. Additional work. After receipt of an order which adds to the services, coach may, at its discretion, take reasonable action and expend reasonable amounts of time and money based on such order. Client agrees to pay coach for such action and expenditure as set forth as an addendum to this agreement at that time for payments related to services. Duties and responsibilities. Coach responsibility and disclaimer say. Coach hereby agrees to provide and perform for the client those services set forth in this agreement. Coach shall devote its best efforts to the performance of the services and such other services as may be reasonably requested by the client. B. Coach shall use its best efforts to comply with, and to ensure that each of its agents comply with, all policies and practices regarding the use of facilities at which services are to be performed hereunder. C. Personnel supplied by coach to provide services to client under this agreement will be deemed coach's employees or agents and will not for any purpose be considered employees or agents of client. Coach assumes full responsibility for the actions of such personnel while performing services under this agreement and shall be solely responsible for their supervision, daily direction and control, provision of employment benefits, if any, and payment of salary, including all required withholding of taxes. D. Coach may disclose income reports, results, and success results of other clients or former clients or customers, including product reviews and testimonials from time to time. All efforts are made to accurately represent such information, but there's no guarantee that client will achieve the same results by using those techniques or ideas shared by the coach. Client is encouraged to perform its own due diligence and research and is solely responsible for its earnings and results. Client's earning potential and results are contingent upon their individual personal circumstances, abilities, experience, and skills. Therefore, client agrees not to hold coach and/or its officers, employees, successors, shareholders, joint venture partners, or anyone else working with the coach liable for any successes or failures directly or indirectly related to the information, reports, reviews, products, and/or services shared with the coach. Client responsibility. Coach provides the coaching services under this agreement strictly for educational and informational purposes only. Coaching services provided by the coach shall not be construed as professional advice tailored to any specific individual. Coach has multiple clients and all information shared is for educational purposes intended for the general people. Client is encouraged to always seek a professional in the area for its particular needs and circumstances before making any professional, legal, financial, medical, or tax-related decisions affecting the client or its business. Client agrees that use of coaching services is at client's sole risk and that client is solely responsible for the accuracy of the personal and any information provided by the coach, outcome of client's actions, personal and business results, and for all other use in connection with the coaching services. Client agrees to assume full responsibility for progress and results from the coaching services. Coach makes no representations, warranties, or guarantees verbally or in writing of any kind. Client agrees that its individual results may vary and that no promises of any kind are made by the coach. Client agrees to assume all risk of loss for participation in the coaching program and services with the coach. Coach does not promise or guarantee that client will reach their goals as a result of participating in this coaching program. Maintenance of confidentiality. Each party hereto, such party, shall hold in trust for the other party hereto, such other party, and shall not disclose to any non-party to the agreement any confidential information of such other party. This constitutes a mutual non-disclosure agreement. Confidential information is information that relates to such other party's research, development, trade secrets, or business affairs, but does not include information that is generally known or easily ascertainable by non-parties of ordinary skill in computer systems design and programming. Confidential information does not include information that A. was in the coach's possession before it's being furnished by the client. B. is generally known to the public or in the client's industry. C. is obtained by the coach from a third party, without breach of any obligation to the client. D. is independently developed by the coach without use of or reference to the client's confidential information. Or E. the coach is required by statute, lawfully issued subpoena, or by court order to disclose. F. is disclosed to the coach, and as a result of such disclosure the coach reasonably believes there to be an imminent or likely risk of danger or harm to the client or others. And G. involves illegal activity. The client also acknowledges his or her continuing obligation to raise any confidentiality questions or concerns with the coach in a timely manner. Coach hereby acknowledges that during the performance of this contract, the coach may learn or receive confidential client information, and therefore coach hereby confirms that all such information relating to the client's business will be kept confidential by the coach, except to the extent that such information is required to be divulged to the coach's clerical or support staff or associates to enable coach to perform coach's contract obligation. Coach agrees not to disclose or use, except as required in coach's duties, at any time, any information disclosed to or acquired by coach during the term of this contract. Coach shall disclose promptly to client all inventions, discoveries, formulas, processes, designs, trade secrets, and other useful technical information and know-how made, discovered, or developed by coach, either alone or in conjunction with any other person, during the term of this contract. Coach agrees that he shall not, without the written consent of client, disclose to third parties, or use for his own financial benefit or the financial or other benefit of any competitor of client, any information, data, and know-how, manuals, disks, or otherwise, including all programs, decks, listings, tapes, summaries of any papers, documents, plans, specifications, or drawings. Both parties shall take all reasonable precautions to prevent any other person with whom they may become associated from acquiring confidential information about each other at any time. Both parties agree that all confidential information shall be deemed to be and shall be treated as the sole and exclusive property of each party. Upon termination of this contract, coach shall deliver to client all drawings, manuals, letters, notes, notebooks, reports, and all other materials, including all copies of such materials, relating to such confidential information which are in the possession or under the control of coach. Non-disparagement. Both parties agree not to make any false, disparaging, or derogatory statement in public or private, whether in writing or orally regarding each other, its employees, clients, agents, or anyone else working with the parties. For the purpose of this agreement, the term disparage includes without limitation statements or comments made in any form or medium in the press or social media that could potentially affect the business of each party adversely or tarnish the reputation of each party in any way. No transfer of intellectual property. Nothing contained in this agreement shall be construed as granting to any party a license, express or implied, under any patent, copyright, trade secret, or other intellectual property right now or hereafter owned, obtained, or licensable by a party to this agreement. Any intellectual property made in the performance of this agreement shall be or remain the sole and exclusive property of that party who created it, regardless of whether it is completed or reduced to practice thereafter. In the event that employees of the parties jointly produce copyrightable material, such material shall be jointly owned and copyrighted with rights reserved for both parties, and both parties shall share in the cost, if such copyright is registered. If during the performance of this agreement inventions result, the following shall apply. Each invention, discovery, or improvement, hereinafter referred to as invention, conceived or first actually reduced to practice by one or more employees of one of the parties, shall be the sole property of the party whose employee or employees made the invention. Any inventions conceived or first actually reduced to practice jointly by employees of both parties hereto shall be jointly owned by both parties. Nothing in this agreement is intended to transfer to the client any rights in the coach's services or work performed, which shall remain the sole property of the coach. Client is not authorized to use coach's intellectual property for client's business purposes. No license to sell or distribute coach's materials is granted or implied to the client. Injunctive relief. Both parties acknowledge that disclosure of any confidential information by each other will give rise to irreparable injury to the owner of such information, inadequately compensable in damages. Accordingly, Either party may seek and obtain injunctive relief against the breach or threatened breach of the foregoing undertakings, in addition to any other legal remedies that may be available. Status of coach. Coach is an independent contractor, and neither coach nor coach's staff is or shall be deemed to be employed by client. Nothing contained herein shall be construed to constitute the parties hereto as partners or joint venturers, or either as an agent of the other. Client is hereby contracting with coach for the services described herein, and coach reserves the right to determine the method, manner, and means by which the services will be performed. Coach is not required to perform the services during a fixed hourly or daily time, and if the services are performed at the client's premises, then coach's time spent at the premises is to be at the discretion of the coach, subject to the client's normal business hours and security requirements. Coach hereby confirms to client that client will not be required to furnish or provide any training to coach to enable coach to perform services required hereunder. The services shall be performed by coach or coach's staff, and client shall not be required to hire, supervise, or pay any assistance to help coach who performs the services under this agreement. Coach shall not be required to devote coach's full time, nor the full time of coach's staff to the performance of the services required hereunder, and it is acknowledged that coach has other clients and coach offers services to the general public. The order or sequence in which the work is to be performed shall be under the control of coach. Except to the extent that the coach's work must be performed on or with client's computers or client's existing software, all materials used in providing the services shall be provided by the coach. Client shall not provide any insurance coverage of any kind for coach or coach's staff, and client will not withhold any amount that would normally be withheld from an employee's pay. Coach shall take appropriate measures to ensure that coach's staff is competent and that they do not breach this agreement. Termination of coaching relationship by the client or the coach. At any time, either the client or the coach may terminate, without liability, the coaching period for any reason, with or without cause, by giving 30 days advance written notice to the other party. The client shall pay coach the compensation to which the coach is entitled through the end of the coaching period, and thereafter all obligations of the client shall terminate. Termination obligations. Coach hereby acknowledges and agrees that all property, including, without limitation, all books, manuals, records, reports, notes, contracts, lists, blueprints, and other documents, or materials, or copies thereof, proprietary information, and equipment furnished to or prepared by coach or its agents in the course of, or incident to its rendering of services to the client, including, without limitation, records and any other materials about invention ideas belong to the client and shall be promptly returned to the client upon termination of the coaching period. Following termination, neither coach nor any of its agents will retain any written or other tangible material containing any proprietary information. The representations and warranties contained herein, and coach's obligations under this section, shall survive termination of the coaching period and the expiration of this agreement. Assignment, successors and assigns. Coach agrees that it will not assign, sell, transfer, delegate, or otherwise dispose of, whether voluntarily or involuntarily, or by operation of law, any rights or obligations under this agreement, nor shall coach's rights be subject to encumbrance or the claims of creditors. Any purported assignment, transfer, or delegation shall be null and void. Nothing in this agreement shall prevent the consolidation of the client with, or its merger into, any other corporation, or the sale by the client of all, or substantially all of its properties or assets, or the assignment by the client of this agreement, and the performance of its obligations hereunder to any successor in interest, or any affiliated client. Subject to the foregoing, this agreement shall be binding upon, and shall inure to the benefit of the parties and their respective heirs, legal representatives, successors, and permitted assigns, and shall not benefit any person or entity other than those enumerated above. Indemnity. Limitation of liability. Except as expressly provided in this agreement, the coach makes no guarantees, representations, or warranties of any kind or nature, express or implied with respect to the coaching services negotiated, agreed upon, and rendered. In no event shall the coach and or its officers, employees, successors, shareholders, joint venture partners, or anyone else working with the coach shall be liable to the client for any indirect, consequential, or special damages, either in contract or tort, whether or not the possibility of such damages has been disclosed to coach in advance, or could have been reasonably foreseen by coach. Notwithstanding any damages that the client may incur, the coach's entire liability under this agreement and the client's exclusive remedy shall be limited to the amount paid by the client to the coach under this agreement for all coaching services rendered through and including the termination date. Disputes. Any disputes that arise between the parties with respect to the performance of this agreement shall be submitted to binding arbitration, governed by the laws of the state of Michigan, to be determined and resolved by said association under its rules and procedures in effect at the time of submission, and the parties hereby agree to share equally in the costs of said arbitration. Governing law. The parties agree that this agreement shall be construed under and governed by, both as to validity and performance, and enforced by the internal laws of the state of Michigan applicable to agreements made and to be performed wholly within such jurisdiction, without regard to the principles of conflicts of law or where the parties are located at the time a dispute arises. Representations and warranties. Both parties represent and warrant that each party has full power, authority, and right to execute, deliver, and perform under the terms of this agreement. No other consents are necessary to enter or perform this agreement. This contract contains a binding arbitration provision which may be enforced by the parties. One-on-one legal compliance. The coach represents and warrants that it and its employees have all the necessary qualifications, licenses, permits, certificates, and registrations, if any, required to perform the services under this agreement in accordance with applicable state, federal, ethical, and local rules and regulations, and that it will perform the services as per the client's guidelines and specifications with the standard of care prevailing in the industry, including those forbidding sexual harassment, discrimination, and unfair business practices. Entire agreement modifications. This agreement constitutes the entire agreement between the parties hereto about the subject matter hereof, superseding all prior understandings and agreements between such parties, whether written or oral, for such subject matter. This agreement may not be amended or revised except by a writing signed by the parties. Attorney's fees. Should either party hereto, or any heir, personal representative, successor, or assign of either party hereto, resort to litigation, to enforce this agreement, the party or parties prevailing in such litigation shall be entitled, in addition to such other relief as may be granted, to recover its or their reasonable attorney's fees and costs in such litigation from the party or parties against whom enforcement was sought. Severability. The provisions of this agreement are severable, and the invalidity of any provision shall not affect the validity of any other provision. Any invalid or unenforceable provision shall not be deleted, but shall be reformed and construed in a manner where it is enforced to the extent compatible with applicable law. Captions. Captions have been inserted solely for the convenience of reference and in no way define, limit, or describe the scope or substance of any provisions of this agreement. Waiver. Neither party will be deemed to have waived any of its rights, power, or remedies hereunder except in writing signed by the party. A waiver by either party of a breach or violation of any provision of this agreement shall not constitute a waiver of any subsequent or other breach or violation. Notices. Any notice or communication given or made by either party under this agreement shall be in writing either by personal delivery, mail, registered or certified, or by email at the address listed above. Mailed notices shall be addressed to the parties at the addresses listed above. Both parties agree to keep each other informed about their current business and mailing addresses as well as email addresses and phone numbers. Force majeure. Neither party will be deemed in default of its obligations to the extent that the performance of any such obligation is prevented or delayed by war, insurrection, fire, flood, riot, acts of terrorism, strikes, acts of God, telecommunications failures or errors, systematic internet failure, including but not limited to interruptions by service providers, or any similar event or circumstance not caused, in whole or part, by such party, and which is beyond the reasonable control of such party. Counterparts. This agreement may be executed in two or more counterparts, including by telecopier, telefacsimile, or by electronic means, such as by encrypted digital signature, by electronic mail transmission of a portable document format, PDF scan of the original document, or a copy thereof, and when so executed, will have the same force and effect as though all signatures appeared on a single document. Emails and copies of signatures are acceptable in lieu of originals. In witness whereof, the parties hereto have signed this agreement as of the date first above written. This contract contains a binding arbitration provision which may be enforced by the parties. Signature section of agreement. Raven Pontiac Media, LLC 5420, Beckley Road, number 365, Battle Creek, Michigan, 4901. 5 support at ravenpontiacmedia.com, as of August 28, 2025.